did have a dedicated sanctions session last week for those of you who were there. If you weren't, you're more than welcome to watch the video on our YouTube channel. But they're all definitely interrelated and have an interplay from a money laundering and a terrorist risk financing perspective. So a lot has been happening. I'm not going to talk about grey listing and the mutual evaluation process in too much detail, other than to say that we did go through the mutual evaluation process. There were quite a few recommendations that came out of that. One of them was specifically in terms of improvements to beneficial ownership. So for those of you who like the technical stuff, we have 11 immediate outcomes. So those are kind of like the thematic groupings from a FATF perspective of how we can demonstrate effectiveness of our AML and CFT framework. Beneficial ownership sits under immediate outcome 5. And it's within that context that certain changes needed to be made. Changes needed to be made holistically in respect of our AML and CFT framework. So apologies, AML, anti-money laundering, CFT, counter-terrorist financing, and then also, of course, counter-proliferation financing. The changes there, why I say it is holistic, it's because it is relevant not only just in respect of the FIC Act, but also in respect of other legislation that touches on beneficial ownership. So Yolandi is going to take you through a lot more detail of the changes, but maybe just as an opener, for those of you who are maybe aware of the recent legislative changes that took place, it took place through what we used to call it the GLAB because it was an easy acronym. Now we call it the GLA, which just sounds ridiculous, but it's the General Law Amendment Act. And essentially what that is, it's an omnibus piece of legislation. Now, the way I always like to explain it is, think of a bus. You only have one vehicle, but there's a whole bunch of people sitting within the vehicle, which is ironic because we're talking about beneficial ownership. And that's the same principle of this omnibus legislation. It was one piece of, so it was one act, one piece of legislation, but within that, there were multiple pieces of legislation that were impacted. Changes to the FIC Act, where we brought in definitions and enhancements to the issue relating to beneficial ownership, and then also things that touch on from a CIPC perspective, for argument's sake, where there are amendments or proposed amendments rather to the shareholding schedule moving to 5%, shareholders holding more than 5% having to register their information at the CIPC. So there's a lot of changes that took place that had an interplay from an AML CFT perspective, all took place through the GLAA, and that then had knock-on impact. So you'll see that the FIC Act was amended, the CIPC legislation was amended, the Trust Property and Control legislation was amended. There were several pieces of legislation that were amended. Now, in today's presentation, what we are going to be doing is we're going to show you how that actually impacts. So if you had a look at this before December last year, the slides are going to look a little bit different, and that's because it takes into account the legislative amendments. Also on the horizon is quite a few of our guidance products, updating PEPs. We are looking at releasing our beneficial ownership guidance product very soon for consultation. But I think I'm going to leave it there. I think that sets quite a nice scene for today's discussion. A reminder then, because I see a lot of these questions popping up, yes, the session is recorded. Yes, you are going to receive the slides. If you are going to take photos of the slides, not a problem. I just ask that if we're in it, make sure that it's a good shot of us. If not, you can always retake it. But I'm going to hand over then to my colleague, Yolandi Plaatjes. Thank you so much, Yolandi. Over to you.
Thank you so much for that, Ashley, and a warm welcome to everybody who's joined. Just a reminder to everybody to complete the attendance register link. It is posted in the chat box. We've seen that there's quite a few comments around no sound. So we have advised, and one of our producers will also put up a note to say, please use the WebEx application at least, if you're having difficulty with sound. So that being said, let us jump straight into the presentation. Now I'll turn off my camera for now. You'll see that there's a whole lot of acronyms that we always refer to. I'm not going to go through each and every one of these acronyms, but do know that later on in the presentation, we are definitely going to speak about FPEP, which is a foreign politically exposed person, and a DPEP, which is actually a domestic politically exposed person. So just bear that in mind. Okay, so that being said, why the focus on beneficial ownership? Why is it so important for us to, as accountable institutions, to actually identify and take reasonable steps to verify beneficial owner? Well, it's quite straightforward. It's because we have seen from different trends, international and both domestic, that criminals often use corporate structures, the likes of companies and trusts, to actually launder their ill-gotten gains. So there are scenarios where a criminal will actually open up a company and they'll use that company to channel through dirty money. And that term, actually, money laundering, did come from cases where laundromats were created as front companies, and those criminals would then use that front company to channel all the proceeds of crime, like drugs and gambling, illegal gambling, and so forth, through those companies. The company would then give it an air of legitimacy, and in that way, that criminal uses the company to hide behind and evade detection by law enforcement. In recent times, you've also seen what's referred to as the Panama Papers, where a whole lot of trusts, we actually are a law firm in Panama, was implicated for assisting to create a whole lot of trusts and a whole lot of companies for people all over the world. And of those people, obviously, there was criminal elements, and those trusts and companies was used to evade, for tax evasion, and also evade law enforcement and so forth. So there's a definite risk. Domestically, if you just think about the risk of those fly-by-night companies being started up during the COVID time just to get COVID funds, that risk of criminals using companies as a front has been highlighted domestically. So it does pose a major challenge, and it has been highlighted in the FATF mutual evaluation report. It has been highlighted that accountable institutions really need to get it right. They really need to identify that beneficial owners better. And so this type of sessions is aimed at providing a bit more guidance towards it. I have to state at this point in time that there is a draft guidance product that will be published in time to come. And of the principles that we're going to cover in today's presentation, the principles will be covered in that draft guidance product as well. And it will then provide you as an accountable institution with an opportunity to then comment on principles around beneficial ownership, how to interpret beneficial ownership, and how to also apply it. So just note that in the back of your mind, and I'll just highlight it throughout the presentation as well. Okay, so we all know that South Africa is a member of the Financial Action Task Force, and we do adhere to the Financial Action Task Force recommendations. Recommendation 24 and 25 deal specifically with transparency and beneficial ownership of legal persons and legal arrangements. So there, recommendation 24 states that the country must put in place measures to prevent the misuse of a legal person for money laundering or terrorist financing. And also a country must ensure that there is adequate, accurate, and timely information available on beneficial ownership. And then similarly, recommendation 25, which deals specifically with legal arrangements, a legal arrangement such as a partnership or a trust. It also indicates there that measures must be put in place to prevent the misuse of legal persons. So how we've done that is through the FIC Act. We have got Section 21B of the FIC Act, which is a measure that's included in the domestic legislation, which states that accountable institutions must identify and take reasonable steps to verify the beneficial owners of their clients. And in that way, they can better monitor also that funds that are channeled to those beneficial owners and report any suspicious and unusual transactions through to the center. So it's all part of the mechanisms which actually prevent the misuse of legal persons. So I've alluded to it. FATF recommendation 24 and 25 is incorporated in as part of South Africa's domestic legislation through Section 21 of the FIC Act. Section 21B at least, sorry, of the FIC Act. Section 21B, if you look at it, you'll see it sets out the entire requirements that relate to beneficial ownership. And that, when I talk beneficial ownership, it means not only clients that are companies that are legal persons, but also clients that are trusts as well as partnerships. So we'll go a bit more in detail through the FIC Act right now. If you look at the FIC Act, Section 20, it says that you may not establish a business relationship with a person that is anonymous. You may not have an anonymous client. You need to know who you're dealing with. You can't deal with a person who's given an apparent false or fictitious name. As a minimum, you must have obtained some sort of information on the client. If a transaction is above 5,000 Rand and it's a single once-off transaction, then the Section 21 actually states that you must identify and verify your client. Your client being a company or trust or partnership in this type of scenario. You'll identify that company, partnership, or trust. You'll also identify that company's beneficial owners. Then there, Section 21 also goes further to state that if you establish a business relationship, regardless of the amount of the transaction involved, if it's an ongoing business relationship, ongoing transactions that are being processed for the client, then it is deemed a business relationship. And in that scenario, you also need to identify and take reasonable steps to verify your beneficial owners, and you'll identify and verify the company in that type of scenario. Some of the comments coming through is saying sound is okay. Hopefully that WebEx app is working. Okay. So just a bit more detail on Section 21B. There, Section 21B does state that the accountable institution must obtain information on the nature of a client's business. So if you think about nature of a client's business, if you're dealing with a company, you'd want to understand what exactly that company is dealing in. So what sector the company deals in, what type of goods and services that company provides. You ask your client that type of questions to understand exactly what type of transactions are going to be normal for the client, or your client that is either a company, a trust, or a partnership. You'll ask that client also for the ownership and control structure. So there's a whole lot of examples of what type of documents can give you insight on the ownership and control structure of a company. For example, if you look at the company's organogram, if you look at prospectus, if you're dealing with a trust, if you call for the trust deed, a signed partnership agreement, shared certificates, or even a signed letter from an auditor outlining the ownership structure of a company. So those are the type of documents you would ask for when you actually trying to determine what is the ownership and control structure of your client. From that, you would then be able to determine which all persons, at least natural persons, has ownership shares in that entity. And you'll also be able to determine what type of ownership shares, if any, in that client. So it's important to understand upfront the nature of a client's business as well as the ownership and control structure of the client. It forms the basis of you identifying the beneficial owner. And you'll obviously do this in line with your RMCP. You'll determine what type of documents you call for, whether it's the organogram, whether it's a letter from the auditor, whether it's the share certificate and so forth. You will determine that type of thing. There was substantial amendments made to Section 21B of the FIC Act. If you look at the General Law Anti-Money Laundering Combating Terrorist Financing Amendment Act, which came into force in December 2022, you'll see the definition of beneficial owner was updated, as well as Section 21B of the FIC Act. The amendments that came through was to provide further clarity to the requirements. So there was questions around, hang on, if my client is there was questions around how to apply beneficial ownership and also findings in the mutual evaluation report, which indicated that South Africa had to further clarify through our legislation. So in the next few slides, I'll just highlight those amendments and it will become a bit more clearer from there. Okay, so now you've onboarded your company, you've asked the company what sector they deal in, you've asked them for the organogram. From the organogram, you can see that they've got how many, 5 or so shareholders, and you can see the different percentage that each shareholder has. You will then now be able to identify a beneficial owner. And this is one of the main updates that was brought about through the General Law Amendment Act, the definition of beneficial owner. It now indicates that beneficial owner means a natural person who directly or indirectly ultimately owns or exercises effective control of a client of an accountable institution or a legal person, partnership, or trust that owns or exercises effective control of, as the case may be, a client of an accountable institution. It also, a beneficial owner may also include a natural person who directly or indirectly exercises control over the client of an accountable institution on whose behalf a transaction is being conducted, and includes, in respect of a legal person, a partnership, and a trust. So here from this definition, it becomes very apparent if you're dealing with if your client is a company, and in turn, that company has shareholders that is also companies, you need to drill down on those legal entities, that company, and find an actual natural person. Further examples in further slides will be, it will clarify it a bit further because it is quite technical. But this is the clarity that this definition sought to bring in, to show that you should not stop by a legal person. You must drill down and find the actual natural person as a beneficial owner. So yeah, concepts of legal owner and beneficial owner comes into play. And you need to understand that for a beneficial owner, it's always going to be a natural person that you must identify. Don't stop at a shareholder, for example, that is a legal owner. Scroll down until you find a natural person that owns that shares, and that natural person is then deemed the beneficial owner. So there, the legal owner of legal person B in the diagram can be legal person C, where legal person C is then owned by a natural person. The natural persons are then the actual beneficial owners of the legal person B. So don't stop at the legal person C. Go a step further to find out who is the actual natural person who owns legal person C. And that natural person would then be your beneficial owner in this type of scenario. So when you are determining the nature of a client's business and also the ownership and control structure, what we do advise accountable institutions is that they should understand the different types and forms and basic features of the different legal persons, trusts, and partnerships that they might onboard in future. So if there's different types of companies that you deal with, that you know you usually deal with, if there's different types of organs of state, even if there's non-profit organizations, if there's foundations, any type of legal person or legal arrangement, try to understand the different type and the form and the basic features of that legal person or arrangement. And also understand the manner in which it's created. And also the different types of beneficial owners that different types of legal persons or legal arrangements may have. For example, a company will have shareholders, a cooperative will have members, and so forth. A partnership will have partners, and so forth. You obviously have to identify what type of beneficial owners each type of client could have, and also the different levels of risk that each different type of a legal person or legal arrangement might have or pose to your organization. It's been said that different legal persons pose different risk. If you look at, for example, a trust, there's heightened risk of money laundering involved in dealing with an entity that's a trust in comparison to maybe an entity that's a listed company. Because listed companies are subject to more regulation and there's more disclosure requirements and so forth, it makes them a bit less risky if you compare it to a trust, which is subject to a bit less regulation and so forth. So you can risk rate the different types of entity types that you have. And this is purely just an example table. It just shows you how you as an accountable institution can list the different types of entities that you might come across and deal with. And in a different column, you can set out who would possibly have controlling ownership interest, who would possibly have effective control through other means, and also who would be classified as management of that entity. It just makes it a bit easier when you're dealing with that legal person or arrangement. You have an understanding of what exactly you are looking for when you're dealing with that entity. So you can develop a table similar to this, a comprehensive table which lists all the different entities. It is merely a recommendation. I see some comments asking, is this a requirement? This is a recommendation. Develop this type of table, set out who you will deal with in future. This is the requirement in actual fact. When you onboard a legal person, your first point of call is you're going to try and establish who the natural persons are who have a controlling ownership interest. If you're in doubt, you then go to the next step and you try to identify the natural person who exercises control through other means, including through his or her ownership or control of other legal persons, partnerships, or trusts. Or you go to identify the natural person who exercises control over the management of a legal person. So this is set out, and it's actually a summary of Section 21B, subsection 2, which deals with specifically legal persons. And when you onboard, for example, a company, you would then follow these steps to identify the beneficial owner of that company. So the next few slides are going to be based on this 3 steps. Your first step being trying to establish who has controlling ownership interest. And again, yeah, I'd like to highlight that this type of, this slide includes a principle that is yet to be consulted on. The principle of 5% beneficial ownership threshold being used as a percentage threshold that helps you identify which natural person you have to identify. The Financial Intelligence Center will publish guidance, as I've noted up front, and you will then have an opportunity to actually provide consultation comments on what threshold you believe is suitable and the reason for your submissions on those thresholds. Having said that, the deciding factor when determining whether a person owns controlling ownership interest in a legal person is whether that natural person has influence over the decisions taken by the legal person and the operations of that legal person. Controlling ownership interest can be determined with reference to the percentage ownership that that natural person has in the legal person, and also with reference to the overall level of influence that that person can exercise over the legal person. So currently, Guidance Note 7 indicates usually 25% is a good indicator of controlling ownership interest. However, planning on issuing guidance, draft guidance, and this draft guidance will in all probability indicate that this threshold is now moved to 5%. So the requirement will be for you to identify the natural person who has 5% controlling ownership interest in that legal person. A hybrid approach would be the best to identify the person, the beneficial owners in this type of, for this first step. So you'd first try to identify the person who has a 5% controlling ownership interest. You'd then also conduct an overall assessment to see if you've missed out on any persons who actually can exercise influence over that company. 5%, the use of 5%, we have tried to align it to Regulation 32A of the Companies Act. Again, the General Law Amendment Act brought in this 5%, where affected companies are required to establish and maintain a register of persons who hold beneficial interest equal to or in excess of an amount of 5%. So again, this is not set in stone. This 5% is not set in stone. We are mentioning it up front right now so that you can already become aware of the thoughts that the regulators have around the percentage threshold. In time to come, that draft guidance will be published, and you'll definitely have a chance to actually comment on this threshold amount. And we urge you to provide as much comment as possible on this, because it is definitely something that's going to impact all of the accountable institutions. Concern with only applying a 5% threshold, there may be scenarios where you actually miss a person who can exercise influence over a legal person. So now you apply, if you, for example, apply a strict identifying of a person who has owns 5% in a company, there may be another person who actually can take decisions and steer the company's operations. And in that manner, that other person actually is deemed a beneficial owner. So in addition to applying the threshold of 5%, also just assess the legal person holistically to see if there's any other person that influences the operation of that legal person and is able to benefit from that legal person. There are scenarios with complex structures where there's actually multiple layers. For example, where a company belongs to a group and a natural person owns a small percentage ownership interest in each of the different subsidiaries of that group or holding companies of that within that group structure. And if you combined that percentage across the group, you find that that person actually owns more than 5% in combination. In that type of scenario, that person would then also be deemed a beneficial owner. So there's also scenarios where different shareholders can actually enter into some sort of shareholder agreements where they agree to take decisions in a certain aligned manner and so forth. And in that manner, that grouping of shareholders who've got the shareholder agreement can then exercise control over the company. That makes sense. So it's very technical. All of these points are very technical. We have included it in this presentation just to make you aware of what is coming and the thoughts we do have around beneficial owner. And you will definitely be given an opportunity to comment and to provide consultation comments fully on this topic, so that we do reach a point where a set principle is applied across all the accountable institutions. There may be also other factors that warrant you identifying a person as a beneficial owner. If you think that the legal person that you're dealing with, the company that you're dealing with, is high risk, if you believe that that company type is high risk, you as the accountable institution can then take the decision to identify and verify all persons who has ownership interest in that company. If you see that a beneficial owner is a foreign politically exposed person or a high risk domestic politically exposed person, then you can also in that type of scenario take a decision in terms of your risk-based approach to actually identify and verify that natural person that you've identified, that is the FPIP or the DPIP. If you see that the company that you're dealing with is all over the news and you believe that company is high risk, they've been implicated in a lot of corruption cases and so forth, you can then also take the decision to identify all of the shareholders of that company, the natural persons who are shareholders of that company. You don't have to, what we're saying is, you'll apply a minimum threshold, the 5%, but over and above that, you can apply more stricter percentage threshold based upon the risk that you've identified. That's basically what we're trying to indicate. So these are just diagrams of what we've been what I've been saying. Company X authorized representative wants to buy a property on behalf of Company X. So they approach the estate agent. The estate agent would then ask for the information on the Company X. What is the nature of the Company X's business? What is the control and ownership structure of Company X? And from that, accountable institution is then able to see that Company E actually owns a controlling ownership interest in Company X. But further, S owns a controlling ownership interest in Company E. S, the natural person, is therefore deemed the beneficial owner, and the accountable institution would then have to identify and verify this person is in this scenario. The register has been posted. For those asking about the register, we'll just ask that our producers publish the link to the register again. In this scenario, we see that Company M wants to open a bank account on behalf of Company M. Company M is owned by person S. Company M is also owned in part by Company T. Company T in also owned by persons R, P, and W. And if you look at the ownership interest there, you'll see that person R has majority voting rights. If you compare it to person P there, that person has no voting rights. So there also, this type of example shows you that different shareholders have different types of shareholding interest. And it also plays an important role in that person R, in all probability, can take the decisions that influence and control Company T, as opposed to person P in this type of scenario. So then there you'd, if all being said in this scenario, if person R owns 5%, controlling ownership interest in Company M, ultimately, then person R and S would be your beneficial owners, the natural persons who own controlling ownership interest in Company M. The scenario just shows you that a trust can have shareholding in a company, and further then you need to identify and verify the trust fully. And if the trust has, obviously that will include identifying and verifying the trustee, founder, and beneficiary in this type of scenario. It goes further, and this is where the amendment came through the General Law Amendment Act to clarify this type of scenario. If the trustee in the scenario was a company, then you would also apply the process of elimination to identify the beneficial owner of that trustee type of scenario. So it does become very complicated. And it is something that definitely it takes a bit of practice and also reading and understanding to wrap your head around this concepts of beneficial ownership. So that was the first step. The second step when it comes to legal persons, as set out in section 21B, is it states that if you are in doubt and you can't identify the person who controls, has a controlling ownership interest, then you try to identify the natural persons who has control through other means. And this one is a bit more straightforward. It could include that natural person who has power of attorney or nominee shareholders, or persons who through court orders actually exercise control through other means over a legal person and so forth. So the scenario is a bit more straightforward. Then, so this is the second step, or you can do the third step. A lot of accountable institutions skip straight through to the third step. And the third step states that you can look at the management of the legal person as the beneficial owners. So yeah, this would include your directors, your executive officers, and so forth. And in practice, this is definitely what most accountable institutions do. Most accountable institutions go directly to the third step. And the bad news about that is that when the inspectors come through, when the FIC inspectors or the inspectors from SARB or so forth come through, they are going to want to see some sort of process of elimination was followed. Meaning, try to, I'm going to go back to the slide. You first try to identify the natural person who has a controlling ownership interest. And then thereafter, you were in doubt and you couldn't. Then you moved over to the second step or the third step. And you didn't directly go through to the third step when onboarding a client that is a legal person or legal arrangement. So just make sure that you are able to demonstrate when an inspector comes to inspect your institution that you've actually made provision for the process of elimination in your RMCP. You follow the 3 steps to identify beneficial owners when it comes to legal persons. And in that way, you'll then, if your process provides for that, in that way, your RMCP is quite, it would be up to standard. You'd meet the requirement as set out in section 21B, subsection 2. Going on to, so that brings us to the end part of legal persons. Let's move on to trusts. Trusts are a bit more straightforward. Yeah, we say that when you're dealing with a trust, your client is a trust. You'll identify and take reasonable steps to verify the trust, the trustee, the founder, the named beneficiaries. If the beneficiaries are not named, you ask for the particulars of how a beneficiary is determined. The reason why you are required to ask for all of these natural persons' identities is because each and every one of them can actually benefit from a trust. It's not only beneficiaries that can benefit from a trust, a trustee as well as a founder can in certain instances. And a lot of the instances, I go back to the earlier example, with the Panama Papers, where a lot of founders actually channeled illicit funds into trusts, and thereafter they also benefited from that trust. It's one of the examples that shows you that not only a beneficiary of a trust is set to benefit, but also a trustee and a founder can. It depends on the way in which the trust is set up. If your trustee or your beneficiary is a legal person itself, then you also need to follow the process of elimination. And the amendment to section 21B, it's also to clarify this requirement. It wasn't being applied in practice, and it wasn't being interpreted in this manner. So just note that if your trustee or your founder or any of the named beneficiaries are also legal persons, then you'd follow that process of elimination that I've covered in the previous slides. Then on to partnerships, and I'm reaching the end part of my slides. On to partnerships. Yeah, you'd identify each partner that partner to the partnership, regardless of what percentage that partner owns. If a partner is a legal person, then you'd also apply the process of elimination to identify that legal person. Right up to at the beginning, we've mentioned the FATF recommendation 24 and 25, which says that we must obtain adequate, accurate, and up-to-date information. There, just note that your adequate information, you must know who the beneficial owner is, the natural person, and you must obviously know the ownership and control structure. Accurate information, you must be able to source reliable information on beneficial owner. And then up-to-date information, if beneficial ownership information changes over time, you would then have to update your CDD information. This is just part of ongoing due diligence. Something important to mention also is the importance of understanding your beneficial owner when you're dealing with a company that's involved in public procurement. So that's been highlighted in South Africa time and time again. You'll see on the news, you'll hear reports of companies that have been set up purely to gain from corrupt public procurement contracts and so forth. So when you're dealing with a company that deals with state, that gains from public procurement, please make sure that you apply some sort of, the recommendation would be to apply some sort of enhanced due diligence and make sure that you fully identify and verify your beneficial owners in that type of scenarios. The beneficial owners of your company does impact the risk. So just understand that when you're onboarding and you see that one of your beneficial owners is a sanctioned entity or sanctioned person at least, know that Section 26B would apply and you would not proceed with that type of transaction because you can't provide services to a sanctioned person, even where it's a beneficial owner that's sanctioned. If there's negative findings on a beneficial owner, there it can impact the overall risk rating of your client. If your client is a foreign politically exposed person, your beneficial owner is a foreign politically exposed person, there too it will impact the risk. Your client would be seen as higher risk, and so forth. So who your beneficial owner is, it definitely does impact the risk rating of your client that you deal with. And that being said, it brings me to the end of the portion that deals with beneficial owners. I will then hand back to Ashley, who will then take you through politically exposed persons. Thank you.
Great. Thank you so much, Eleni, and sorry for blankly staring into my screen. I was just trying to share the slides. Maybe if I can just check with my producer, are you able to see my slides? Fantastic. All right, great. So again, thank you, Yolandi, for that discussion. And I think just by looking at the kinds of questions that are coming through, it's quite varied from very entry-level understanding of beneficial ownership, and some of you that I can see have really been dealing with very complex type of queries. Specifically, when you're dealing with complex structures and a lot of very specific kinds of questions that have come through. And I think the one thing that I want to emphasize before I get into the discussion of politically exposed persons and what that interplay is is with the amendments and the way that we have a look at UBO from a South African perspective. Yes, it is based off of international standards. Our legislation is a little bit different. It's not copy and paste from the EU for argument's sake. So discussions like the use of thresholds, certain percentage thresholds is a very country-specific view, again, dependent on the kinds of risks and the kinds of structures that we have in place. One thing that I always want you to remember, whether it be going through the PEPs discussion or going outside of today's session, is the principle really does talk to the look-through principle. So when you see an organization, you only see the shell of the organization. You see the company's name, you might see the brick and mortar of the organization if it's an actual, if there's a building. But what we need you to do is to look through that and to look through who are the people who are actually controlling it and actually benefiting from the organization itself. And that is really the principle we refer to as the look-through principle. Many different principles can be applied. I know sometimes they call it the warm body or peeling back the onion layers. It really has many different things, but it all means the same. Look through the organization and see who is actually benefiting, who is calling the shots, who is in control of the organization. And the reason we say that is the company isn't the one who's going to benefit at the end of the day. It's the person who makes the decisions. It's the person who receives the benefit at the end of the day. Yolandi had already mentioned corporate vehicles are a fantastic way for criminals to try either hide themselves or hide their assets or disguise or to create layers between the illicit funds and themselves. And it's really for this reason that we thought it would be pertinent to discuss how politically exposed persons, what is that interplay with beneficial ownership. I mentioned a little bit earlier as well, and I think Yolandi concluded on it, is sanctions is also something that's very relevant and something that you need to consider. We're not discussing it in today's session, and that's purely because we had a full-on focused session on sanctions last week. But also bear in mind, because a natural person is trying to hide behind this a corporate veil, we call it, everything that they do and everything that they are, whether they be a politically exposed person or a sanctioned person, or they've done something which makes their risk a heightened risk, that risk in and of itself is attached to the organization. And that's very important. And it's important from a risk profiling perspective, and it's important from the way in which you engage and how you understand your business relationship with the corporate structure. The corporate is the people who comprise the corporate structure itself, right? So let's go through some of the basics when we're talking about PEPs. We are going to draw the dots a little bit later, but I think just to make sure that everyone is on the same page, let's discuss what PEPs is, or who PEPs are, if I can put it that way. When we're looking at the Act itself, I wouldn't be a good compliance officer if I didn't tell you what section to look at. Look at section 42.2L of the FIC Act, and this talks specifically to the RMCP, what needs to be in the risk management compliance program in respect specifically to PEPs. So what the Act says is you need to be able to determine the client is a domestic PEP, a foreign PEP, or a politically influential person. You need to obtain senior management and approval to establish a business relationship, obtain source of wealth, and conduct enhanced due diligence in particular instances. So not in every single instance, but in particular instances, which we'll discuss. And then there's also around your data sources. How are you going to go out and how are you going to access this data? You'll see then on the guidance tab, there is a host of guidance available that you can go and find additional information. Guidance Note 7 really is the golden source of information, and this product was released in 2017 when there were the significant changes, and we actually moved from rules-based to risk-based. PCC 51, which is in the process of being amended. Then there are the underlying sections in the Act, which talks to what needs to be done when you're dealing with a domestic person or domestic PEP or foreign PEP, a politically exposed person, as well as close known associates and family members. And then most importantly, so who is a PEP? How is it defined? And this is specifically defined in the schedules to the Act. So 3A tells you every position that a person fulfills, that would be a domestic politically exposed person. Likewise with 3B, it tells you particular, my words have just left me completely now. It gives you a list of particular activities or particular positions that if a person were to fill that position, they would then be a foreign politically exposed person. Likewise with 3C in relation to prominent influential persons. Now, the reason why I'm spelling it out here is it's not a list of people's names. It's a list of positions that people can hold. There isn't a list. And I know there were many questions in the chat already, and there's many questions that we get asked through our call center and our queries, and when we engage with people face to face. There isn't a solid one list that the FIC can provide. PCC 51 does have some examples, but we'll get into that a little bit later. 3C talks specifically then to a set threshold, the threshold that needs to be set by the Minister of Finance. And this really relates to organizations who deal with or do business with government entities. And that's really kind of what 3C is dealing with. So people who generally, people who deal with like tender deals, have engagements with very large values of funds with states, state or organs of state rather. The threshold hasn't been set as yet. Right, so if we get into the definitions then, I already mentioned when you look at the schedules aren't names of people, but they're names of positions that can be held. So a politically exposed person is that person who holds or has held a prominent public function. They have a particular level of influence and control over public funds, benefits, and decision-making. Now, I'm going to skip kind of to the end slides. Just because a person is a politically exposed person, the Act and the FIC is not saying that these persons are all linked to illicit activities, that they're all linked to corruption and bribery. That's not at all the point of what we're getting at. What we're saying is, given the level of influence and the level of control that you have as a person in that particular position, the risk from a money laundering and a terrorist financing perspective increases. All right. When that person in that position abuses the power, now remember, you're talking public funds, we're talking millions here, and I don't even need to explain it because I know what we've all read and what we've been exposed to. But when a person abuses that position, it results in corruption and bribery, and that in of itself can be a predicate offense to money laundering. So remember, when we're dealing with money laundering 101, excuse me, you've got your dirty money, you take it through a process, through placement, layering, integration, and then you take it out so that you can actually use the money. Bribery and corruption is the dirty money, and taking that thing through the process and through your organizations could then amount to an abuse from money laundering perspective. A significant change that took place, Yolandi touched on some of the amendments that took place in December, is once a PEP, always a PEP. Now, what it used to be was, in certain instances, if you were a PEP and you hold the position for 6 months and more, you would consider a PEP. If you were a PEP and you had left your position, so you no longer held that position for over a year, then you would no longer be considered a PEP. And in our guidance, we had spoken around, well, you know what, the risk still remains. Just because you weren't a PEP doesn't mean that you don't have, a particular level of influence, or you don't have connections anymore. But that's not really that relevant anymore, given the change that was made, and that is once a PEP, always a PEP, as simple as that. So if you had held that position irrelevant, you would still be treated as a politically exposed person. This change was also a mutual evaluation finding, and it aligns to the FATF principles. So if you look globally, the principle of once a PEP, always a PEP applies. Right, so in the determination of a politically exposed person, and I know sometimes we use FPEP and DPEP, but please don't get confused with the acronyms. They're not formal acronyms. We just use them because there's only so much space on a PowerPoint presentation that we have. But what we're saying is what you need to do is you need to be able to determine if a prospective client, so that means a client who's not a client yet, so during the process of onboarding, an existing client, because remember, I might not be a PEP when I get onboarded, I might become a PEP, or I might fill a position that makes me a PEP maybe 6 months later or a year later, because anything can change. The beneficial owner of the client, and this is kind of where this link is coming in between what Yolandi was talking about, and also a person acting on behalf of the client. All right. Why? Because this is the person who can make the decisions for your organization. You need to be able to determine if all 4 of these are a domestic or foreign PEP or a politically influential person, as well as if they're an immediate family member or a close known associate of that domestic PEP or politically influential person. You need to go through a process of identifying and assessing money laundering risk in relation to the PEPs, a domestic PEP, and then you need to then make sure that this is documented in your RMCP. We are going to talk about it a little bit more, but why do we specifically say you need to assess the money laundering risk for a domestic PEP? We didn't make a mistake. We didn't leave out foreign PEP. And that's because a foreign PEP is always considered to be a high risk. Yes, you still need to go through the process and understand, the risk factors. I know Yolandi took you through some of them a little bit earlier, but you need to have a look at like your client risk, your geographic risk, your products, your distribution channel risk. So it's all those risk factors you still need to consider, but a foreign PEP is always considered a high risk from a money laundering and terrorist financing perspective. A domestic PEP, you need to go through that process to make that determination of are they a low or medium, or are they actually a high risk? So how do you go about doing it? So there's two ways. First and foremost, you can ask, get the information directly from the person. And then also there's a process of scrutinizing client information. So this would be the likes of open data, commercial databases, although I need to put a caveat that the FIC doesn't, promote or require you to make sure of a particular commercial database, and also in terms of independent research. Now, remember, it's important. I'm just going to go back one slide when we're talking about any one of the positions that you see here. So it's either a client, so before they become a client prospective, the clients, which talks about, that ongoing relationship with your client, the beneficial owners, as well as the person acting on behalf. Also includes family members, close known associates, and the person themselves. So what does this mean practically speaking? Generally, and I'm sure we've all filled in application forms where we've been asked this question: do you hold a prominent position? The next question would be, are you related or have a family member or an associate to anyone who is a politically exposed? I'm just going to pause there because I do see some comments popping up, which I don't think is quite conducive to today's discussion. So if I can please ask, this is a forum for learning. Sorry to get on my horse here, but please, can you just keep the questions to the topic at hand? And if there's any concerns or disgruntlement around the FIC and our processes, I ask if you can please just have the courtesy not to post it on the open forum chat. All right. So when we're talking about identification factors, when we're dealing with customers and due diligence, we need to make sure, so I had mentioned a little bit earlier, there's 2 ways in which you can obtain information. First and foremost, you can ask the client. Now, this is kind of a double-edged sword. So in the instance where they say, and this is the last bullet, yes, I am a politically exposed person, this is my position, or yes, I'm married to one, or yes, my dad is one, or whatever the case may be, where they've acknowledged it, you can accept that on face value. And we say that in the sense is no one's going to go out of their way to let you know that they're a politically exposed person, because they know that it attracts enhanced scrutiny and enhanced due diligence. So you can take that on face value. The flip side of the coin is where they say no. Where they say no, the guidance that we've provided in terms of PCC 51 says you do need to go a little bit deeper and you do need to scrutinize that information. So that's really just it's a cautionary tale when you're looking at a CDD perspective, because of the consequence that can result. All right. When you're talking about corporate structures, and this is maybe just a little bit of repetition again to explain the link. When we're looking at corporate structures, they generally get abused for hiding or disguising illicit dealings, and they can also make use of family members and close known associates. So I know we might have discussed beneficial ownership from a corporate perspective or from a corporate vehicle or a company perspective, but it can also take place from a one-on-one perspective, which is what the definition also covers now. So I, as a person, also might, be directed or instructed by another individual. A person who is trying to evade detection, classic, make use of a corporate structure. They can also then make use of another person. So I can ask my friend to use her bank account. I can ask my spouse to make use of their bank accounts, etc. And that is why a close known associate and family members is also then included. The last thing that I want to mention from a CDD or from a risk consideration perspective is the risk that is associated with the politically exposed person themselves is going to impact on the risk that is associated to the corporate entity. So let me say that again. That's the last bullet. Let me read it. The money laundering and terrorist financing risks that is associated with the politically exposed person themselves will impact on the risk that is associated with the corporate client. So in other words, the corporate entity or the close known associate. We're going to get into some examples now so that we can demonstrate what we mean by that. All right, so the first example then is, and I'm going to go through it slow because I know examples can be a bit confusing when we're talking about A's and B's and C's, but there is a little diagram in the bottom right-hand corner that kind of depicts what we're trying to do. So an accountable institution onboards client X, who is a legal person. So that is the corporate structure that you see in the middle of the diagram. The beneficial owners of client X is Mr. P and Q. So there you can see it's the down arrow for P and Q. The person acting on behalf of Mr. X, or I beg your pardon, of client X is Mr. R. So that's the guy on the left, right? So when you're looking at the structure, this is, I think, is a quite easy and straightforward one. The accountable institution needs to scrutinize the information obtained in relation to all of these natural persons. So Mr. P, Q, and R, to see if they hold any positions relating to politically exposed persons. So whether it be a foreign or a domestic. Okay. Just a reminder again that the same would apply from a sanctions screening perspective. So if Mr. P, Q, or R was somehow a sanctioned individual, then you have a problem because then they are somehow hiding behind the corporate structure. Okay. If, say now, Mr. P or Mr. Q was a foreign politically exposed person, doesn't mean that you cannot proceed with the transaction or the business relationship. All it means then is that risk for the client, so the corporate structure, is now a heightened risk. The second example I have here, so if you have a look again, the diagram is more of a simple diagram. Accountable institution onboards the client, Mr. X. Mr. X is the husband of Mrs. X. And you'll see there Mrs. X is only put into a gray block so that we can demonstrate that she is the person where the risk lies, all right, or the direct risk, if I can call it that. The accountable institution needs to scrutinize the information regarding Mr. X and determine that he is a family member of Mrs. X. So again, practically speaking, if we had that little tick sheets or onboarding form, are you related to any particular person, etc. And is that person a politically exposed person? You need to then assess the risk that is associated with Mrs. X. So just like Mrs. X would be a client of yours, if Mr. X is associated to anyone who is a politically exposed person, you need to understand the risk that that associated person holds. So if Mrs. X, for argument's sake, is a high-risk domestic pet, or if she is a foreign pet, which means she's automatically a high risk, that is definitely going to impact the risk of Mr. X, pushing him also then into a much higher risk category, and he would be dealt with as though he was a pet. So all the enhanced due diligence, the sign-off processes, etc., which we will talk about now, will kick in. The last example, okay, I think the last example is on the next part. This is just to reiterate what I mentioned, where that risk of a associated person is a high risk, it impacts on your actual client risk, and therefore you are going to have the additional compliance obligations that would then apply. The third example then, so the third example is a trust example. So the accountable institution onboards client B. Client B is the trust. So that's the little corporate image that you see on the top. And the sole beneficiary is person X. Person X is a PIP. So if you had a look, and we must apologize, in our previous slides, we hadn't included the donors and trustees, and we confused people because it seemed like they weren't important. So the donors and trustees are important. Yolandi spoke about them already. When you're looking at it from an onboarding and a customer due diligence perspective, yes, when we're looking at a trust, we're looking at donors, we're looking at trustees, and we're looking at beneficiaries. They are all relevant from a risk profiling perspective. But in this scenario, only Mr. X, who is the beneficiary, is a foreign politically exposed person. And he is in kind of like the rounded brackets at the bottom, or bubble, I don't know what you call that image. All right. So in that respect, accountable institution A needs to comply with Section 21F of the Act and apply enhanced due diligence. 21F, fancy way of just saying you now have a foreign PEP, which is a high risk, within your structure. All right. And that's why it's so important to understand the full picture of your beneficial ownership, to see who in that picture could potentially be a heightened risk. That would definitely have a knock-on risk impact to the client, which is the trust. And I think just to close that loop then, and it was based on some of the questions that we were getting in, do you first determine if your corporate client is a high risk, and that would then tell you how far you need to go down? The answer is no, it's the other way around. You need to understand who is part of your structure before you can determine the risk. Why? If I did it the other way around, I might not have necessarily known that Mr. X was a heightened risk. Okay, so always first look at your structure. First, Yolandi mentioned it, I'm not going to repeat, do your 3 steps, identify the people who are involved. Once you've identified them, then you need to start doing the scrutinizing of information of those individuals. Okay. All right. When we were talking about the obligation, so what is it that kicks in? So when I have identified, and this is just a reminder at the bottom of the screen there, this is in relation to high risk domestic PEPs and all foreign PEPs. Why? Because all foreign PEPs are deemed high risk in terms of the PEP Act. There are additional obligations over and above your customer due diligence and your enhanced due diligence. So remember, the higher the risk, the more customer due diligence needs to be performed. In addition, you need to make sure that senior management approves the onboarding of this client, or the approval of the product or the service, or entering into the contract. You need to establish the source of wealth and funds of the client. Okay, so source of wealth, how do I make my money? And source of funds is, where does it actually come from? So is it coming from bank accounts? Is it coming from a third-party deposit? And my wealth is obviously, how is it that I generate my wealth? Is it through, I'm just a salaried employee, or I'm a salaried employee and I'm a chairman on several boards, and I've got a trust? That explains where my wealth comes from. The source of the funds explains where the money is actually coming for this particular transaction. And then there is the enhanced ongoing monitoring. So why is this relevant? Again, if we go back 10 slides where we spoke about access to public money, access to make decisions, having influential sway, again, over public funds and public or decisions that can impact the public, is very important for us to know where your funds and your wealth are coming from. If someone says they're purely a salaried, so an example of a heightened risk could be a politically exposed person tells you they're only a salaried individual. You go and have a look at the annual statements or the annual report for that particular organization, because their salaries have to be declared. Say now it's only 1.5 million for the year, but they are purchasing a 40 million rand house, for argument's sake, or purchasing a 6 million rand car. When you look at the source of wealth and funds and you have a look at the transaction that you're dealing with, this is where you can start picking up discrepancies and where you're able to flag suspicious behavior. Okay, so I'm not going to go into too much detail, but maybe just to go through some indicators of what could actually make a politically exposed person a high risk. So again, when we're dealing with domestic politically exposed persons, And these are just some ideas or some things that you can think of. So first and foremost, the nature of the position. So what is the level of influence? What is the nature and the seniority that this person has? Obviously, the more that they have in a more prominent organization, the more heightened the risk. If a person says that they are not a PEP, but they are actually a PEP, therein immediately is a bell ringing. Why would you not want to disclose? I mentioned earlier, people who disclose that are okay because you know you're going to be under enhanced scrutiny. The flip side is opposite. By not declaring, you don't want people to know. Okay. If they avoid providing you with any information, so they're very vague in their responses around what job they do. If they're a beneficial owner or part of senior management or exercise control through other means, again, it doesn't mean, please don't get us wrong, it doesn't mean off the bat they're a high risk. It's just an indicator. Where a legal person, trust or partnerships, avoid providing beneficial ownership, right? Again, why do you not want to tell us who is part of your structure? What is it that you don't want us to know, or who is it that you don't want us to know of? And then also if they avoid providing source of wealth or source of funds. Again, you don't want to tell me why you make your money. You don't want to tell me where the money is coming for the purchase of this particular asset or engagement. It raises some flags. If there's negative media or any reports on them, but again, that's a common risk flag for anyone. Negative commission reports or judicial findings, either for them or their family members. If there's been any unethical conduct noted of them, if they have access to government funds, public funds, or major public benefits, also something that you need to consider. If there are credible allegations of money laundering, terrorist financing, proliferation financing, bribery or corruption, or if there's been any previous convictions. Now, we often get asked, the media is what the media is, and it's very difficult for people to rely solely on media. But now what we're saying is but you also don't live in a bubble, and this information is freely available to you. And we do say that you must make use of independent research and open source information. Where this information is there, you'll see there we talk about credible allegations. Just bear that in mind. When you're doing a risk profiling, remember, risk profiling, A, does not mean that the person has done something wrong, and B, it doesn't mean that you should no longer engage with that person. It just means that your level of scrutiny and the risk or the perceived risk would be heightened. Okay. Some more things to consider for risk rating, where the domestic politically exposed person is associated with persons who have been convicted. So either the previous one we said, either the PEP themselves have been convicted. Here we're talking the flip side of if they are associated to someone who has been convicted, if they've been previously charged, if either they or their family or close known associates, their transactions and the activity do not align with their source of wealth and their source of funds. That's what I mentioned earlier. I'm only a salaried employee. I earn X amount, but I'm purchasing something ridiculous, which is way over what I can actually afford based off of source of wealth and source of funds. Likewise, the assets don't align with their source of wealth and funds, and also where accounts are being held in other countries. Just want to go back to that. We had quite a bit of a debate around this particular one. Just because you have an offshore account doesn't mean that you're doing anything wrong. You might just be smart and diversifying your portfolio. But again, it was one of those classic trends of, if I don't want South African authorities to know, how much money I have, one of the easiest ways is by putting it offshore, which is interesting because if they put it offshore in a country that follows the FATF principles, they would also be identified as a foreign PEP and would have a heightened level of scrutiny. We spoke about currency accounts, offshore accounts, movement of funds offshore, cross-border, large values of cash transactions, because again, the nature of a politically exposed person's salary, isn't to be paid in cash. It is generally going to be paid into a bank account. If there are deposits made and movement very quickly out, if there's numerous accounts in different banks, and also if they provide or if they avoid providing information. So this slide is also it's not specifically to PEPs. Things like putting in money and sending money out quickly, having multiple bank accounts are indicators from a client perspective in general, but definitely what you can consider from a PEP perspective. Right, so I am nearing the end, and I think this is maybe just some of our concluding remarks on PEP. So we really have discussed now who they are, what they're about, what the legislation says that you need to do, who's high risk, what do you do if they are a high risk. Now we're talking about de-risking. So de-risking is the process of either not onboarding someone or ending a business relationship with them purely based off of the fact that they are a politically exposed person. Now, this is something that we definitely do not advocate. And we are of the opinion, and by so we, the figures of the opinion, that it is not effective as adequate risk management if you just off the bat de-risk a client only for the fact that they hold a position of a DPEP, a domestic PEP, foreign PEP, or a prominent influential person. All right. It is the fixed view that de-risking based solely on the fact of what I mentioned now is the position that you hold without considering any other money laundering risk factors or any controls that you can put in place or any form of reporting would not have amounted to following a risk-based approach, and it would amount to non-compliance with that risk-based obligation. When you are, so don't get us wrong, if you go through that process and you do the review and you really have an understanding of the money laundering risk and the terrorist financing risk, but you are of the opinion, taking into consideration your risk tolerance, that you do not have the risk appetite to take this client on board or to continue with the relationship, there is a termination process. Make sure that your onboarding documents and your client forms are very clear in terms of how you can exit a relationship with the clients, because you can't unilaterally just end relationships. There's other pieces of legislation and corporate law that you need to consider. But from a FIC Act perspective, if you terminate a relationship or you do not engage with that relationship after doing an adequate risk assessment, then you would have complied with the obligations of the FIC Act. I know this last slide always sounds very heavy. Okay. To address the question of the sources, so yes, we already said that you can talk directly to the client. No, we do not have a particular list. There's not one list. There are commercial databases out there. We do not say that you have to have one. So if you don't have a commercial database, you're not going, and an inspector comes one day to review you, you're not going to be penalized because you didn't engage with the commercial service provider. And that's just because we also can't endorse them. The positions are very clear in the schedules. If you look at PCC 51, which we are in the process of updating to take into consideration the legislative amendments, there are examples of different databases that you can access, which are free of charge. Okay. All right, so this then concludes the presentations. I'm going to stop sharing my screen. So, like I mentioned, we really do have a lot of questions that have come through in the chat, and unfortunately, we're not going to be able to get to all of them. There are some very technical questions as well, which are also very scenario specific, and I'm going to apologize up front because we're not going to be able to attend to those particular questions, purely because, and I think it's from something that we've learned in the past, we might not necessarily have the full context to your question. We don't have an understanding of who the client actually is. And I think any advice that we give you could very easily either be incorrect advice or maybe misunderstood. So please, if you have asked a particular scenario question, we aren't going to address them for that reason. What I do want to say from a principles-based perspective, and this is how we're going to be addressing the questions going forward, is maybe just the starting point, again, with the look-through principle. I think maybe we should start with some of the UBO focus on the UBO questions, and then we can maybe move over to the PEP questions. When we're talking about complex structures, and I maybe just want to go to the principle around the look-through principle. The look-through principle really is around looking at the corporate structure, looking through, identifying the natural persons that actually have either control or can make the decisions that can sway and move the direction of the organization. And they're the ones who benefit from the organization's dealing at the end of the day. Yolandi spoke in quite a bit of detail around the process of elimination. So that's 3-step process. Now, remember, the ball is in your court. When you are satisfied on a particular level, there's no need to move down to a level. It's only when you cannot identify and determine the person at the first level that you would move down to the 3rd level. All right. I'm maybe going to leave it there on that particular discussion and then open up the Q&A box. Received. Sorry, it's a little bit slow. While I'm waiting for the questions to pop up, I maybe want to start on the high value goods dealers. A few of you have asked a few questions, and although not specifically related to the topic at hand, I think it is important that we maybe, just address some of the finer details. So some of the questions are predominantly from motor vehicle dealers coming through around, maybe just a clarification around what is required. So remember your definition. So this is for high value goods dealers, of which motor vehicle dealers fall within this category. And this talks to any organization that engages or transacts with a client of 100,000 Rand and more in relation to a particular good. So if your particular item is 100,000 Rand, that is going to trigger the threshold when you're looking at your definition. So any transaction with someone for 100,000 and above, and I'm not talking 3 or 4 items added together, that's not what the definition entails. It's one item, it's one good that triggers the 100,000 Rand threshold. You would then have customer due diligence obligations in respect of those clients. So it's almost like a ring-fenced definition. If your client is below that 100,000, they do not meet the definition for purposes of the FIC Act. So they would not have to fall part of your customer due diligence profiling, etc. Sanction screening is a little bit different because you cannot deal with the sanctioned person, irrelevant of if it's 5 Rand or 500,000 Rand. So a lot of questions with regards to, if it's below 5,000, do I need to worry about it if they're a PEP? If it's above 5,000. So for motor vehicle dealers, please remember you are working within your 100,000 Rand category. The amount is 5,000 Rand. So if it is above 5,000 Rand when we're dealing with a single transaction, so this is dealing with anyone else who's not a high value goods dealer, because there were a few questions around, has the threshold changed? When is it going to change? Just a reminder that when you're dealing with that, know that the value hasn't changed. The cash threshold report has changed, which we're not discussing today, but the value is 5,000. Okay. All right, so I'm going to start then with the questions, and I'll maybe knock some of the easy ones off, and the difficult ones I'll ask Yolandi if she wouldn't mind. She's sitting next to me in case you're wondering why I was looking in that direction, if she wouldn't mind. So there was just a simple question here around who needs to attend the sessions, the compliance officer or the MLRO, and it's really up to you. If you have a look at the obligation of training, the FIC Act says that you need to train your staff in respect of the FIC Act as well as in respect of the RMCP. Honestly, the more the merrier. We love to see lots of people attending the sessions. The more people who can get benefit out of these sessions, the better. But we don't limit it particularly to any particular function that must attend the session. All right. Before we move on to the next question, I think let me be a little bit sneaky and actually pose our survey. So let me ask you to answer some of our questions first before we carry on answering your questions. So if I could just ask the producer to please pop quickly the attendance, I beg your pardon, not the attendance register, the survey. Again, very simple questions. We are using it purely for purposes of assessing how our session went. Did you actually learn from it? Was it valuable? And then also being able to determine what topics we need to consider going forward. So I will continue answering the questions just to get a quick sense that it has been perfect. It has been, oh, I see it popped up right now. So please do fill out the survey. There was 2,090 odd people who attended today's session. So we're really hoping that we can get 2,090 odd responses back. Okay. There were some questions around the CIPC submissions around passport details and where there's errors submitted. Unfortunately, the CIPC and the FIC are, we're friends, but we're not that close. Unfortunately, we wouldn't be able to advise on any of this, the CIPC processes, document submissions, etc. That's a little bit out of our area of expertise, and honestly, I don't I don't know that process. Some of the questions are just talking around having a consolidated list. We already spoke about that. We don't case. There was a question, and maybe Yolandi, something that I can pose to you. Someone was asking us if there's we've already determined risks, why don't we provide them with what is required per risk? So the way I'm understanding it, if it's low risk, you need this. If it's medium risk, you need,
Thanks for that, Ashley. So it's definitely right. We don't prescribe to the accountable institution what documents you need to obtain and what information you need to obtain. It is part of the accountable institution's risk-based approach. So it actually affords the accountable institution that discretion to determine what type of documents you are going to call for, to determine the control structure of an entity, and also the identity of the beneficial owners. So that is part of the risk-based approach. It does afford you that discretion. Ashley, if I may add on to your earlier point on CIPC, I do note, and it may be useful for the colleagues online, the CIPC has published a guidance product on the beneficial ownership disclosure. So I would urge you to Google and find that actual guidance product. It might answer a lot of the questions that you've been asking. Thank you.
Great, thank you for that, Yolandi. And I think if we can, from our side, I'll make a note to look for get that link to the guidance that Yolandi was referring to now. And then we send out the confirmation of attendance. We will just include that link for you. Okay. Could we provide examples of RMCP documentation? Nice and easy. We have a PCC already issued on this. PCC 53. PCC 53 is more for smaller organizations. So, if you're in a bank or more of a global company, unfortunately, this isn't for you. It's meant more for small and medium organizations. We also have a template in there. Now, the template doesn't mean you can just fill in your name at the top and sign the bottom, but it guides you and aids you in at least the minimum amounts of information that needs to be in there. And there's certain areas where it actually forces you to fill in your own information. So we would talk about CDD, you would then need to capture what CDD would be required for a low risk or a medium risk, but the template does prompt you. Okay, so just a reminder, PCC 53. Some very specific questions which our fingers are already itching to have a look at, but we aren't going to be. One around templates for beneficial ownership and the deadlines. I'm assuming that relates to the CIPC stuff, which maybe if we can just pause on the threshold question, Yolandi. I know that you already mentioned it, what was in guidance and what we're proposing, to align with more international standards and to align with the CIPC legislation. But maybe just a final word on your thoughts on the application of a percentage. So is it legislative? Is it a consideration? Is it something they should think about? If you could maybe just take us through the percentage again.
Thanks for that, Ash. Yeah, definitely. I think it shouldn't be as daunting as it seems at the moment. The change from 25%, at least the proposed change in terms of a FIC requirement from 25% to 5%. In that, and it has been a major development if we look at it as such, in that CIPC does now require that 5% declaration on beneficial ownership. So in that manner, it is actually going to make it a whole lot easier for accountable institutions to get this type of information. So I guess a word to accountable institutions on this is to don't see it as being too daunting, in that this information is definitely going to be made available, or at least it is going to be collected by the regulatory authorities. And in time to come, obviously, then the accountable institution can ask for it from the clients directly. So yeah, guidance note 7 does make reference to 25% currently, and we definitely are in the process of updating our guidance, and we are going to issue draft guidance. And as I've mentioned earlier, that draft guidance is going to be indicative of a threshold that we are going to prescribe to accountable institutions. Thank you.
Thank you, Yolandi. And I see we've got some honorary FIC staff members in the audience today posting our documents for us. I think it was Jolene. Thank you so much for that. It's really well appreciated. And it just goes to show, that people are making use of our website. Okay. A question here around where do we load BO on FIC? Okay, I'm not actually too sure what that means, but just if I can hazard a guess, there isn't an obligation to provide that information through to the FIC. This is information that forms part of your onboarding process and your normal customer due diligence process, ongoing monitoring of your clients. It's information and documentation that would then be stored within your organization. And only when an inspection is taking place would you then be asked to provide us with that information. It's not something like the CIPC where you have to register certain information. That's not the case with the FIC. Also, when you are doing a registration with the FIC, although most of you, if not all of you, are already registered, we only ask for the information of your compliance officer or your money laundering and reporting officer and a copy of their ID. We're not going to go down to the level of beneficial ownership. Okay, some of the questions I see are very similar, so I'm going to skip some of them. Maybe, Yolandi, just on I'll pose this question to you from a customer due diligence perspective. Once a person has identified they've gone through the process, they've drawn their diagrams, and they've identified who the persons are that they have been identified through the process of elimination, what CDD documentation is then required for those people? And does risk have any form of, or the risk profile of the organization, does that have any bearing on, like the shareholders or the management structures, customer due diligence documentation?
Yeah, there too, it's definitely something that we don't prescribe what type of documents the accountable institution should collect. What we do say is, based upon the entity type, you could find scenarios where you would deem an entity type a bit higher risk than a different one. For example, maybe I like using the example of a listed company. Listed companies are subject to a lot of regulation, call for a lot of documents and so forth to be listed. There you might treat it perhaps as a lower risk, and we don't prescribe what type of documents you would ask that listed company for. Yeah, again, and also questions around state-owned dealings with state-owned entities. I've seen questions popping up on what type of documents and who should we identify as beneficial owner when we're dealing with a state-owned entity. And Ashley has also mentioned, myself included, follow the process of elimination. So it goes without saying, also with state-owned entities, you would follow the process of elimination. Obviously, there, your first step would be to try and identify that person who has a controlling ownership interest, which would be near to impossible in that type of scenario with a state-owned entity. You would then go to the second step, and you'd look for documents that's of that entity that prescribe who is in control of the entity. So if you look at, there's some state-owned entities that are formed by statute. You would look at that statute and you try to determine who is in control of the banking. Is there an accounting officer? Is there a board or so forth for that entity? And then on that second step, you would then apply that second step to it. Same applies for listed companies and also for MPOs. There was a question. Yes, Nathan, thank you very much. Your reference to PFMA and MFMA there is very relevant. Also for understanding who controls that entity in that type of scenario. Non-profit organizations, there was a question around who is the persons that we need to identify and verify as beneficial owners in that type of scenario. We do recommend that you treat it similar to a trust. There you'd also look for your founders, named beneficiaries if there are named beneficiaries, and then if they are not, obviously the particulars of how you can determine a beneficiary. So those were the type of questions I've seen, Ashley, around who to identify and verify on some of the entities. I'll hand it back to you. Thank you.
Thanks, Yolandi. And I think while you were talking about those associated to a government organization, just remember again, because Yolandi spoke about BOs and I spoke about PEPs, they're probably all going to be PEPs, guys. So where you're in an state-owned or an organ of state, or the state has a majority shareholding or some form of shareholding, just bear in mind that immediately in the back of your head, you need to start thinking around potentially the PEP indication and the enhanced due diligence and the sign-off processes that are then going to result as the PEPs being involved in that structure. On the government questions, there was, I think, a similar type of questions, but looking at different angles. You treat them the same. Also, just remember when you're looking at a state's owned or an organ of state, Yolandi mentioned now that they would have, they have to be created. No organization just exists. Likewise with the FIC, if you look at the FIC Act, we are created through the FIC Act. There are certain provisions that gives us our powers and tells us how we need to be structured. So when you're looking at it from a customer due diligence perspective of actually being able to evidence the existence of the state-owned entity, generally it is going to be the legislation that would be your first port of call, and they would know that they're a creature of statute, and they would give you the piece of legislation that would be their founding document, if I can call it that way. And then Yolandi mentioned, agree 100%, you start going down in your levels to try and identify the beneficial ownership there. All right. A question here on how many layers within the ownership and control structure you should go down. And I think we did cover that. So if you've got a very easy organization and everyone is a natural person, I think therein you've struck it lucky, and your UBO process at least is going to be an easier task for you versus if it is a very large, complex organization which has trusts and companies. And those trust and companies have other trust and companies, and only then do you have natural persons. It depends on the structure, and yes, you do have to go down. The point is you have to get to a natural person. You can't end at a corporate structure. I think I saw one or two of those questions. Even if you go down 4 or 5 times, you still have to go until you find a natural person. Okay. So there's no number, there's no limit. Okay. We've spoken about listed companies. Okay, there's calls for the attendance register and the survey to be reposted, but I think it has already been done. There's a question here, Yolandi, I don't know, maybe if you want to take it. It's more around customer due diligence, the information that you receive. So if you've obtained, oh goodness, if you've obtained an ID or proof of address, does it need to be certified? Can it just be scanned or emailed? How many days does it need to be valid for? Can it be done virtually? What's your take on that?
Yeah, going back to that stance on, we definitely not going to tell you that you must collect this type of document and it must be certified in this manner, it must be valid for so long and so forth. That is all within the discretion of the accountable institution. What we do usually say is when you are calling for documents, for information, be guided by what the report, if ever you were to file a Section 29 report, there is certain prescribed information or prerequisite information that needs to be included as part of your Section 29 report. Just be guided by the regulations that speak to reporting on what type of information you need to collect. Be guided by it, but again, just to advise you, it is within your discretion what type of documents you collect and the information that you collect. Thank you.
Thanks, Yolandi. And I'm not going to lie, when I was still a compliance officer in practice, we used to have, I can't remember if it was guidance note 3 or what the number was now, but there were very clear rules. You'd have to have a utility bill that was no older than 3 months, that had to be certified, had to be wet ink, and we would all, do like the lick test to make sure that it would smudge. But those rules are behind us now. I think they're very solid rules, and they're things that you can always consider. Remember, what you put in your RMCP needs to be complied with. So it's document what you do and do what you document. If your RMCP says that these are your certain mitigation risks and you do want it certified and it must be valid, you need to stick to those rules. Guidance Note 7 also says that the best source of information is the direct source. Use that as your guide. It can be electronic, it can be physical. We're not prescriptive on that. All right. The penalties then in relating to if the information related to UBO is not shared with the client and the information is not readily available to the accountable institution. And I think that's a very valid question. That's a very valid concern. What I think here, and we're not unrealistic, and we also know that you guys aren't forensic investigators, you're compliance officers, and you're complying with a piece of legislation. And you really are sometimes reliant on the information that the client provides to you. Now, if you're having a look at beneficial ownership and you do not ask questions and you do not scrutinize information and you don't ask for evidence of that information, then you are going to be found wanting. In an instance where someone does provide you with a shareholder register, it's dated 3-4 months ago, it is signed by the accounting authority, which you've already validated through other company opening documents, and realistically it looks legitimate, you understand who the people are, you engaged with them, you can sign that off. There's a level of comfort because you've gone out of the way to do the scrutiny of information. If they just don't provide you anything and you sign it off in any ways, that is when you're going to get into a host of trouble. You need to be able to demonstrate. I beg your pardon, I believe my sound is gone. Is it back? All right. Apologies to that. I actually saw a sign that said network dipped. So for all of you who saw me randomly staring around the room, we were just checking with our producers. All right. Where was I? Oh yeah, so it was just to maybe repeat for those of you who might not have heard, it really is around putting your processes into your RMCP, putting in processes that would practically assist you to validate information, obtaining information from your client, because when we're talking about beneficial ownership, they really are your source. If you're looking at it from a PEP perspective and you want to know how far do you need to go there, if you haven't even so much as Googled the person or clicked on a link that the guidance has already provided, again, you could very much be found wanting. anything you do, any search that you do on a client, whether it be for UBO, whether it be for PEP or sanction screening, please, you need to keep evidence of this. Keep it as part of your record keeping pack. Not only for, and we always say, if an inspector comes and reviews, it's not only so that you don't get into trouble when an inspector comes, it's so that you can have a holistic view of who your client is. Employees move around. If I leave the organization and someone else takes over my client file, they need to have an understanding of everything that you've done, who the client is, what the concerns were, why you signed them off, and why you agreed to that CDD process. And that's the actual importance of record keeping. Okay. Would it be possible that social media influencers might be added to the PEP definition? Listen, I've got young kids, so I would say yes, but I'm only saying that in light. No changes on the horizon in terms of Schedule 3 at the moment. I think as soon as we get that actual limit involved, I bet you are not involved, the limit approved by the Minister of Finance, will we actually start seeing how that Schedule 3C plays out. So again, that relates to prominent influential persons. And these are those persons that sit at very high levels in organizations like CFOs. I think someone used the C-suite term a little bit earlier, so I'm going to use it now as well. It's really those people that sit at very senior levels, and also people who have engagements with organs of state. Gosh, there's just so many questions, and I know we've only got 4 minutes. What I do want to say is, for the questions that we're not able to get to, there were some real thought-provoking ones that even I was like, wow. We are going to take note of them, and the guidance product that we're going to be issuing is definitely going to be addressing a lot of these questions, maybe not specifically, but definitely thematically. Okay. There was one question that I might have to pause on, and that was just with regards to, and again, I'm not dealing with specific things, but when, there's certain types of trusts or certain types of FSP products, and I maybe just wanted to draw everyone's attention to PCC 52. So for those of you who are authorized dealers, so those of you who are dealing with stock exchange products or products listed on the stock exchange, I don't even know the correct term. There are some instances where your client might be in turn an FSP, and that FSP in turn has their own clients. And this is coming from a beneficial ownership perspective, not necessarily a PEP perspective. In that particular scenario, I think some of the questions were, how do you go about identifying your client's client? Now, your client's client isn't a term we like to use, because from a risk perspective, we always say whoever is associated to your client, whether they're associated to the structure of your client or whether they're associated to the transaction of the client, they become relevant from a money laundering and terrorist financing risk perspective, which means then everyone associated, whatever risk they bring to the table is the risk that gets brought to your client. All right. If you are an authorized user, the conversation is a little bit different for you. Please go have a look at PCC 52, because therein we explain what is the scenario and how do you identify ownership where your client is an FSP and that FSP then has their own clients. Similar principles to what we've discussed today, but I think that would be a very useful document for those of you, again, only authorized dealers, to look at that. All right. So I think we've only got, well, I know we've only got 1 minute left. I'm maybe going to pause it there. Thank you, Yolandi, so much for joining us for today's session. I always call Yolandi the BO queen. She rolls her eyes at me, but she really is very knowledgeable on the subject. So thank you so much for taking the time to join us today. And again, for all of you for joining the session, apologies we couldn't get to all the questions, but really some great questions coming through. And I think as a regulator, it really demonstrates that you guys are applying your minds. Please, the survey, for those of you, I see you all dropping off now because you want to go grab some coffee. For those of you who haven't done the survey, please, will you fill it in for us? Yes, and I guess we will see you at the next event. Stay safe and all the best. God bless everyone. Cheers. Bye-bye.